नमस्कार दोस्तों, सेंट सोल्जर टाइम से मैं हूं कोमल। एक बार फिर हम पहुंच चुके हैं सेंट सोल्जर लॉ कॉलेज में। यहां पर 12th आरसी चोपड़ा मेमोरियल मूट कोर्ट कंपटीशन चल रहा है। आज दूसरा दिन है और बहुत सारे बच्चे यहां पर पहुंच चुके हैं, यहाँ जिसमें ब्रिलियंट और हार्ड वर्किंग स्टूडेंट आज सेमीफाइनल में जाएंगे और फाइनल में जाएंगे। तो वो देखने का हम सबको इंतजार है कि कौन बच्चे विन करेंगे। तो चलिए देखते हैं आज का खास ये मूट कोर्ट कॉम्पिटिशन। एक बात बताना चाहूँगी, यहाँ पर बहुत से दूर दूर से पार्टिसिपेंट पहुँचे हैं, जिनमें से जलंधर के हैं, पंजाब के हैं, राजस्थान के हैं, तमिलनाडु के हैं, तेलंगाना से हैं, उत्तराखंड से हैं, झारखंड से हैं, उत्तर प्रदेश से हैं, वेस्ट बंगाल से भी हैं और डिफरेंट लैंग्वेज से बातचीत करना चाहेंगे। कोशिश करेंगे उनके साथ बातचीत की जाए। तो चलिए देखते हैं मूट कोर्ट कॉम्पिटिशन।
Good afternoon to all of you. Dear students, am I audible? So good afternoon to all of you. Wonderful. It's wonderful to see you all again in this campus and in this auditorium. And once again, it's an auspicious day today that we all have gathered today to celebrate the Moot Court Competition, the 12th RC Chopra Memorial Moot Court Competition, being organized by Saint Soldier Law College. And it's again, as I told you, this is an auspicious day when we have with us the legends, the eminent personalities of the law fraternity, those who have all together come to share their blessings, the vision with all of us. And as a student, you must all feel quite lucky and excited that these men's personalities are present here in your academic life, in your student life, and you are learning from them, you are getting information from them, you are getting inspiration from them. So I feel proud in extending my heartiest welcome to the distinguished personalities on this 12th RC Chopra Memorial Moot Court Competition. Give yourself a round of applause, please. I want to listen. It's a big achievement.
2339. Yes, sir. Yes, if the bench grants me to shorten it up and deliver the facts in 2 minutes, if that's possible. Your Lordship, in the instant matter, I'll be dealing with issue number 1 and issue number 2. Issue number 1, namely, can the conviction be based on circumstantial evidence based in this case? And issue number 2 is the conviction based on retracted confession appropriate? Once preliminary investigation went to the house of the accused, and then, at later on, it is what the police contends that they have given a confession, and based on that confession, police Pulukuri Kotaya versus the Emperor, AIR 1947, which is a judgment of Privy Council, which talks about section 27 and how the recovery is made. Your Lordships, in this case, the recovery of murder weapon on which the entire prosecution is based is flawed in its fundamental clause because it does not blood-stained cloth, blood-stained paper. Police has recovered pieces of glass, and police has also recovered a huge pile of blood. They've prepared a memo, but never proceeded towards the forensics of it. They've also found heavy dragging marks from the roadside, where apparently, which was the crime scene, and they also in their statement have stated that after murdering Sumit, both his friends have threw his wallet and helmet in the jungle. Police has failed to recover any of this. Police later on in the confession given to them apparently has stated that both the accused Your Lordship, I would like to contest that under section 27, only in certain cases such as TADA or NDPS, or should I say, in TADA also, in case of illegal firearms, the recovery is present, and the recovery itself accumulates to the guilt of the accused. But in this case, there is no such thing. In furtherance of this, the police took the confession, later on moved towards the magistrate, and the magistrate recorded this, the statement under 164 of CRPC. Your Lordships, while recording the section, the statement under 164 of CRPC, the magistrate failed to issue the certificate. Apart from this, the magistrate also failed to keep the police officer out of the courtroom. Yes, Your Lordships.
If you read section 26 of Evidence Act, it says that a confession made in immediate presence of a magistrate is admissible. The confession is recorded by the police, but in the presence of the magistrate, then there is no pressure. But you are putting the cart before the horse by saying that when magistrate was recording the confession, the police officer was present there. That meant the confession was not voluntary. How do you justify it?
Your Lordships, when we talk about section 164 of CRPC, 164 also has its corrective measures.
Not about 164. Let us first be clear about it. When the magistrate is recording the confession and a police officer is standing nearby, right? So you feel the magistrate pressurized by the presence of...
But the manner in which the 164 is to be recorded is of charge over here. In this particular manner, the manner in which it is to be recorded is that the accused should be made aware of his rights there, because it directly correlates to his fundamental rights also, which is against self-incrimination.
Acts done by the public servants are done in good faith, right?
Yes.
When a magistrate records this statement, he is presumed to have followed the procedure laid down by 164 and 281 CRPC. How do you come out of it?
Your Lordships, it is an undisputed fact in the fact sheet in the Moot Court Competition, which cannot be disputed at this point of time, which clearly states that the magistrate failed to record the certificate under 164 of CRPC.
This is what I am saying. When he says statement under 164, right? We presume that it was according to 164. What is your argument?
Your Lordships, it is in the very next line contended that it was not there in the problem. Was it its full true nature, or was it out of any kind of threat? Was the accused explain of his right? Was there a sign of magistrate matter? Was it juvenile? And in a hasty manner delivering a judgment, which would also, in this case, there is no recovery of the bike, there is no recovery of the helmet, there is no recovery of...
It is on the statement of the accused. Accused identifies the place that here it is where the knife is hidden, and only then it is recovered. And where is the question of identification by the mother? Should the mother identify the knife?
No, Your Lordships, but apart from that, everything that belonged to Sumit, which could have been used for further corroboration by Sumit's mother, if the wallet would have found anything that could relate back to Sumit.
His clothes were burnt.
Not Sumit's clothes, Your Lordships.
Yes.
Not Sumit's clothes. The clothes of the people who...
But Sumit's body is not recovered. From where the clothes would come?
Your Lordships, when I talk about the burnt clothes, it's not of Sumit, but it is of the accused who went, swam across the river and burnt their clothes.
Your case is that Sumit's body was not recovered.
Yes, Your Lordship.
Right? Clothes must be on the body.
Yes,
or the clothes were left behind by Sumit while drowning.
Your Lordships, it's clearly stated in the facts that in the confession made by both the accused, they first go on the Dilbagh extension, they purchase a bottle of alcohol, they go onto the highway, they try to answer a call of nature, then they stab Sumit. After stabbing him, they drag his body to the river, they dump it there, they swim across the river, they burn their blood-stained clothes, and then hide the knife. It is what... So the police has failed to recover anything apart from the knives. And usually, sir, Your Lordships, in this principle that should have been followed is at least a panchnama or panchas or any independent witnesses should have accompanied the police while recovering the knife. The accused was also not accompanying the police while the recovery was being made, and neither was any independent witness. The police could have hidden the knives over there.
There are hundreds of judgments of the Supreme Court to say acquired illegally is admissible. If a particular procedure was not followed, that will not make the evidence inadmissible.
Oblige your lordship. Your lordships, my also contention is that this case heavily relies on circumstantial evidences. But circumstantial evidence, the prosecution has failed to even bring out the motive or any forensic evidences or any expert witnesses in this matter.
Or you assume the confessional statement before the magistrate.
Pardon your lordship.
Or you challenge the statement recorded before under 164 before the magistrate. What are the grounds for challenging that statement?
Your lordships, under 164 of CRPC, the onus lies on the magistrate so that the confession so being recorded is voluntary and truthful in nature. The whole objective that 164 serves is a strong purpose. It is not an extrajudicial confession, it is a confession given to a magistrate. It is the duty of the magistrate to record in a proper manner. And the proper manner is not just making a certificate. It is that we should see it as a whole. It is to explain the accused of his rights. It is to explain to the accused that it can be used against him in the trial proceedings. If not, it falls against his rights to defense that he can avail during the course of trial.
But as per the facts, the magistrate did not record the certificate under 164.
Stage. If there was an error made by the magistrate, the trial court should have rightfully pointed that mistake out. And after pointing out that mistake, the magistrate should have taken the corrective measures to correct all of and correct under 463. He should have issued that yes, I failed to record a certificate, but it is true to all my facts and beliefs that yes, this person has recorded so and so statement, and not to reduce the validity of 164, which has not happened in this case. And also, when we talk about 164, and your lordships rightfully said that the police's presence, your lordships in different, it is again CRPC is the parent act, and when we talk about the rules that are made by different high courts in terms of when I speak about Madras High Court, they have made a rule that whenever when we talk about 164, it also brings me to the case of DK Basu, where there is some kind of coercion or undue influence on the person making the statement. It should be of full truthness, full voluntariness and truthfulness. But if police is present, upon that, if the magistrate is failing to record the certificate, it disturbs the credibility of 164, your lordships. Hence, I am contesting that when he retracted the confession, the counsel rightfully pointed out that 164 is lapsed and it should not be even admitted in the court of law. And it should be struck down as it lapsed just because the magistrate failed to give the certificate.
Now the question is whether that certificate is mandatory, and if it is not mandatory, then what is the effect of non-recording of statement? Read the section itself where it is recorded that a certificate shall be recorded. What it says.
Your lordships, in the instant matter, there have been lapses at multiple stages, be it during the collection of evidence, be it during making the recovery, and also during the confessional statements that have been made. A similar case was decided by the Supreme Court in this year, which is 2023. It was the case of Inderjit Das versus the state of Tripura. This case is also similar and the facts are also very similar. But here in this very case, the murder weapon was recovered at the roadside, and also alongside it, your lordships, the mother failed to recognize, and the bike was also found in this manner. Yet, Supreme Court has held that it was not enough to grant a conviction, and rightfully trial court has erred while granting a conviction. Your lordships, we are dealing with a similar matter wherein there is nothing corroborative, there is nothing which is concrete to prove the guilt of the accused beyond reasonable doubt. There are multiple doubts. Your lordships, in physics there is a law called Murphy's law, which states that anything that can go wrong will go wrong. And in this case, that very thing has happened. Everything that could have been flawed has been flawed. The police during their investigation, the magistrate while recording, and even if the magistrate has made an error under 164, that was not corrected. The trial court has failed to notice that one person, the same statement. Yes, please.
On behalf of appellants, and I will be dealing with issues number 3 and 4, which is namely whether conviction based on recovery under section 27 is applicable in this case in absence of dead body and absence of forensic evidence, and the fourth issue, which is whether the conviction of the juvenile by the trial court is appropriate. Your lordship, before starting, I would like to read out what Section 27 of the Indian Evidence Act says. Okay, Your Lordship. Proceeding, there are some important takeaways from the Section 27 of the Indian Evidence Act. They are that the fact that is discovered has to be in consequence of the statement that has been given by the accused. The person should be an accused person. He should be in the custody of police officers, and which may or may not be a confession, and should have distinct relation to the fact. Your Lordship, this section is an exception to Section 25. Now what Section 25 says is that no statement or confession given to a police officer is admissible in the court of law, which aligns with Article 20, Clause 3 of our Constitution, which is that no accused person shall be compelled to be a witness against himself. Your Lordship, Section 27 here is contradictory and is in exception to this particular article and this particular section of Section 25. Your Lordship, here I will be contending that this section is illegal. Because, Your Lordship, the law commission.
Can we see the legality or constitutionality of this section while giving an appeal?
No, Your Lordship, but since we are young lawyers who have to take the law forward, we have to. It has to be.
Law is all right, but you have to know the limits also. We are hearing an appeal, not a writ petition.
Indeed, Your Lordship.
We are not a constitutional court as of now. We are an appellate court. And appellate court has to go by the parameters of appeal.
Indeed, Your Lordship.
So, we have to go by what is there in the statute. Statute has Section 27. We have to go by challenge the validity somewhere else, not before us.
Noted, Your Lordship. Proceeding with Section 27, let's break down the section. Only a confession given under police custody is admissible in the court of law, which leads to discovery of a subsequent fact is admissible in the court of law. Here, Your Lordship, in the fact sheet it is clearly stated that the police went to the house of the two accused and procured their statement. Your Lordship, this would not count as custody of police officer, which makes this not admissible in the court of law, which would lead. So, this section basically talks about how the information given by the accused should lead to the discovery of a subsequent fact. Here, Your Lordship, a knife has been recovered. And according to the investigating officer, a knife has been recovered at the instant of the accused. But, Your Lordship, it has nowhere been said, the statement of facts clearly says that the police found the knife which was hidden by the accused. Your Lordship, in the landmark judgment, which is the biblical judgment, in the case of Section 27, that is Pulpuri Kotaya versus the Emperor, which is the Privy Council judgment, in that a very beautiful analogy was given. Your Lordship, there it was stated that if an accused person says that he has hidden a knife, that would not lead to proving that he has committed the murder. If he confesses that he has hidden a knife with which he has stabbed a particular person, then that would constitute as a confession, and that would be the only thing that would be admissible in the court of law. Here, Your Lordship, in the statement of facts, it is clearly mentioned.
First of all, we want a clarification from you on the facts. You said when this recovery was made, the accused was not in the custody of the police.
Yes, Your Lordship.
Right? But if we go by the moot problem, the GD was recorded on the statement of mother of the deceased, and thereafter Sub-Inspector Kishwar Singh proceeded to investigate the matter.
Indeed,
right?
Your Lordship. Indeed.
And the accused is taken in custody.
No, Your Lordship, he was not taken in custody. That is the entire contention. The police were supposed to go and inquire with the two accused who were at their homes. They were supposed to go and inquire. And when they were at their homes, at that time, allegedly, according to the investigating officer, the confession was given through which they recovered the knife.
What is custody according to you?
Your Lordship, the custody is where the accused person is restricted in his movement by the police, because the police is an authority. Your Lordship, the true sense of custody would only be...
And if the person submits to the custody?
Pardon, Your Lordship?
The accused submits to custody. Is there a question of restriction or no?
Your Lordship, the accused did not submit to custody. Now, we are talking about confession here. Confession has to be made willingly and voluntarily. So a person who wants to make a confession will make it in the police station in front of the police. Here the police has gone to their house in the pretext of inquiring about the entire incident, and there they have extracted the confession, and there, according to the police investigating officer, he said that the accused said knife was hidden.
I'll read for you a sentence from the moot problem. FIR against Ganga and Dev was registered, and both accused were arrested under section 302/34 of Indian Penal Code. Right?
Indeed.
This, according to you, is not custody of the police.
Your Lordship, but the recovery was done when the confession that the police is talking about, it was taken at the homes. So they weren't arrested before it, and no FIR was filed before it. They recovered the murder weapon first, and after that they arrested them, and after that the FIR was filed.
What is the custody of the police? Whether the physical custody is required or mere presence of the police in amount to custody when they are accusing somebody of the offence?
Your Lordship, it would not exactly mean only physical custody, because the police would be a person in authority. But Your Lordship, the movement should be restricted. The person who is giving the confession shouldn't feel like he has an escape out of the custody of the police officer. Here at the comfort of their homes, when the police are extracting the confession from them, then it cannot be...
Whether the place of this recording the statement is important, whether it is home or the police station or some street?
Your Lordship, when home comes into equation, then it is important, because home means the comfort of the accused people. It wouldn't mean that they are scared of the police over there.
They could be arrested from the home also. When the police goes there and tells them that they are wanted in a murder case, and they question them, what does it mean?
Your Lordship, the police went for enquiry purposes.
Okay, please proceed.
Your Lordship, it was stated in a landmark judgment by the Supreme Court in the case of Subramania versus the state of Karnataka as to how recovery is supposed to be done. Your Lordship, the court clearly stated that it is the duty of the police officer to call for two independent witnesses in order to record the statement of the accused. Yes, Your Lordship, just propounding what he has said, I am giving you the exact procedure that needs to be followed. Your Lordship, two independent witnesses have to be called. The accused has to be made to give his statement or his confession in front of them. Then the two independent witnesses would attest to that, and that would form the first part of the Panchnama. Indeed, Your Lordship. Coming to the fourth issue, that is whether the juvenile who has been convicted by the trial court is appropriate, is whether the trial court is appropriate in its conviction. Your Lordship, for dealing with juveniles in India, we infamously have the Juvenile Justice Act 2015. Your Lordship, it was the first primary duty of the police that as soon as they knew, it is given in the fact that one of the accused person was a juvenile, and as soon as they knew that, it was their duty to submit their juvenile to a juvenile justice court. Your Lordship, in this case, Juvenile Justice Act has been made a joke out of, because not one provision of it has been complied with. Your Lordship, the juvenile is supposed to be submitted to the Juvenile Justice Board, who will make a preliminary assessment whether to try him as an adult. And a juvenile can only be tried as an adult when he falls between the ages of 16 to 18. May I continue?
Yes.
Only when he falls within the ages of 16 to 18. In the preliminary assessment, the Juvenile Justice Board has to determine whether he has the mental and physical capacity to commit the crime, whether he is aware of the circumstances around him when he is committing the crime, and whether he is aware of the consequences. Your Lordship, this would form the preliminary assessment, after which, if the board is convinced that he has the mental capacity, physical capacity, and all other criteria has been met, then he will be transferred to a children's court. It is only the children's court who has jurisdiction to try children as adults. And this act came after the Nirbhaya Act because of the uproar that was caused during that case. So, Your Lordship, only the children's court will have the jurisdiction to try a particular juvenile in accordance with the Code of Criminal Procedure. That also has not been followed over here. And it is clearly given in the fact sheet that the juvenile was sentenced to an imprisonment for life, which again contravenes the provisions of the Juvenile Justice Act. Your Lordship.
No, what do you suggest in case the juvenile is tried by regular court, whether he is to be straightway acquitted or a separate trial is ordered to be, retrial is to be ordered by the Juvenile Justice Board?
Your Lordship.
What is your prayer?
Your Lordship, a retrial shouldn't be conducted by the juvenile justice board because the juvenile has already gone through the mental and emotional trauma of being encaptured with a bunch of adult hardened criminals, Your Lordship.
The question is, let's suppose we agree with you that he was a juvenile and should not have been tried by the session judge, and instead he should have been tried by the juvenile court. What should we do? Should we acquit him or should we send him to the juvenile board for retrial?
No, Your Lordship, the appellants would always pray for acquittal because, as I said, the juvenile has already spent enough of his time in jail. As this case took place in 2020, he was arrested then, and now it is 3 years later. He was a juvenile when he committed the crime, and now, after 3 years, he has already spent all the time in the jail.
What is the case law on the point in such cases? What is the case law on the point if a juvenile is tried by the incompetent court and then the appeal comes? Whether the retrial should be ordered or it should be acquitted? What is the case law?
Your Lordship, I am not aware of the case law, but I do know that there was a landmark Supreme Court judgment which said this. Sorry?
Which judgment, please?
If I could go back to my researcher and then get back to you.
In rebuttal, you can come.
Sure, yes.
Thank
you, Your Lordship. If Your Lordship is satisfied with the arguments, may I proceed with the prayer? Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, it is humbly requested that this honourable court may be pleased to adjudge and declare that the above appeal is maintainable, that the trial court has erred in convicting the appellants on basis of circumstantial evidence available in this case, that the court has erred in convicting the appellants on basis of retracted confession, that recovery under Section 27 of Indian Evidence Act is not available in this case, and that the decision of the trial court be set aside and this appeal be allowed, and pass any such other order that it deems fit in the interest of justice, equity and good conscience. And for this, the appellant as in duty bound shall humbly pray. Thank you, Your Lordship.
I, counsel number 1, shall be dealing with issue number 1 and 2, and my co-counsel will deal with issue number 3. If your lordships are privy with the facts of the case, shall the counsel raise legally issue number 1?
Yes.
Once applies to lordships. Your lordships, the first issue is, can conviction be based on circumstantial evidence available in the case? So the general rule is definitely not speaking to the case, but in general rule is that the conviction solely can be based on circumstantial evidences. There are plethora of cases on to the point. To cite for your lordships, there is Padala Veera Reddy versus State of Andhra Pradesh and others.
Padala we'll see later. First complete the chain.
Okay, indeed, your lordships. So, your lordships, coming to the chain of circumstances. Chain starts from the very time when Sumit told his mother that I am going with Ganga and Dev for dinner at when he told his mother. First instance, your lordship.
Don't you feel the evidence of mother of Sumit is hearsay evidence?
No, your lordship.
Why?
Your lordship, with regard to that also, I would also like to make that statement of mother relying on the Paklan Ryan Swami case, where it was stated that when the husband went to the place of crime, he told his wife that he received a letter and is going to the spot of crime. Same thing has happened in this case, your lordship, that when he was going, he told his mother that I am going to this particular place to meet this particular people. So relying I have the judgment of Paklan Ryan as your lordship.
No, only to the extent of last scene. Can we base the proposition of last scene on this statement of the mother that he was seen in the custody of, in the company of the accused?
Your lordship, for the last scene theory, there are other instances which will I rely upon.
There is no other instance.
Your lordship, for example, your lordship, with your permission, the recovery of weapon was there, which was based on their confession, which is admissible under section 27.
Recovery will come later. Let us complete the chain first. The chain starts, according to your case, from the statement of the mother that Sumit has told her that he is going with his friends and do not prepare dinner for me. Can this statement be taken to be the statement of last scene? That is the question.
Indeed, your lordship, it can be taken as a last scene theory, relying on that, because not individually, but when we relate all the facts, when we establish the whole chain, then it can be established. I'll give me 1 minute, your lordship.
You mean this is one of the chain chain of circumstance.
Indeed, Your Lordship.
Okay, come to the second chain. How you complete the chain?
So firstly, when we told that Ganga and Dev, police called them that we should come to the police. Now, as per section 8, subsequent conduct of the accused, they did not come to the police when they were asked, so they did not come. That is the second part of the chain, Your Lordship. As per section 8 of Indian Evidence Act, that is admissible, Your Lordship. Third, Your Lordship, come to the recoveries now. Your Lordship, they stated, as per their confessions, that they hide, as per their statement was, weapon of crime. They stated that they put that in a particular place, and the police find that particular weapon at the same place. So this recovery, if not much, Your Lordship, we can presume at least one thing from this recovery, that they were present on the crime scene. Nothing much, just that they were present on the crime scene. From this presumption that they were present, now the last thing we can be established. Since they were there, that is the very important point, Your Lordship. When it is established,
Ulukari says that only that part of the statement under 27 is admissible which tells about the particular fact, right? Not the part that says that I killed the man with this particular knife. That is not admissible. Only the fact that knife was recovered on the basis of the statement, that part is admissible.
we are not denying that, Your Lordship. Definitely, but what other presumption I am asking this court to make, that there are no other hypotheses from this, that if the recovery was made from the exact place, that it only established one point, that they were at least present. We are not asking more, that they were at least present on the spot. This, the court might agree that from this recovery, one thing could be established, that they were present on the spot. Then, Your Lordship, from this, Your Lordship, there are broken pieces of glasses which also corroborate their statement which is given. They stated that they purchased a bottle of alcohol. Now that bottle, broken pieces were also found there, Your Lordship. Then, Your Lordship, there were visible marks of dragging, and which is also being corroborated. Your Lordship, section 7 of Indian Evidence Act and the illustration B, I would like to quote, Your Lordship, that says that the question is whether A murdered B. Marks on the ground produced by a struggle at or near the place where the murder was committed are relevant facts. So from there, Your Lordship, the illustration is very much supporting my case, Your Lordship. It is in the fact sheet, Your Lordship, in this statement.
Pieces of glass were covered. Where will you get it from? The problem says FIR against so was recorded. The police recovered the weapon of crime on the basis of information.
The very first paragraph, Your Lordship. Yes. Your Lordships, these visible marks of dragging, they also establish the whole. Then, Your Lordship, lastly, the judicial confession, which was made by them. So this whole taken into consideration, and with the help of corroboration, it was admissible and the person was convicted. Your Lordship, the last para says that since the confession was retracted, one has to look around to see whether there is any corroboration to connect the accused with the crime, although not containing the full evidence about the commission of offence. In our present case, Your Lordship, the confession is completely being corroborated by every fact which is being there in the present case, as has been established in the chain of circumstances. Your Lordship, they stated in the confession that they purchased a bottle of wine, the pieces of glass were there. They stated that they dragged it, the marks of dragging were there.
Pieces of glass, no doubt, are taken to the government. They are not sent for forensic examination to find out whether the alcohol was there or not. How do you connect those pieces
Your Lordships, the only reason which is probable that police, why didn't they send this particular
We are not
evidence?
asking why, we are asking the effect. Effect of not sending the glass pieces for forensic examination. How do you connect those pieces?
Your Lordships, it is not fatal for the case of the prosecution, even if they have
We are
not
not saying whether we want you to tell us how these are connected with the occurrence.
Indeed, Your Lordship. they are corroborating the confession. They have stated that they were
They
there.
will corroborate only when they are found to be relevant.
Indeed, Your Lordship.
He said these were the pieces of glass of something else, not of that bottle which according to you was used to take liquor. How do you say it was the same bottle? Only forensic examination could say
Indeed, Your
that
Lordship.
we found alcohol on the pieces of glass. There is no forensic report.
Your Lordship's one reason could be that because they already had a confession and they already had a confession on one hand and
not
the
already.
judicial confession, Your Lordship.
Not already. The pieces of glass are recovered first. Confession is later.
Indeed, Your Lordship.
So,
But Your Lordship,
and they never say that these pieces of glass are of that very bottle which we from which we consume alcohol.
but Your Lordship, it raised a reasonable presumption in the mind that they were from Muslim.
So, entire case of yours is based on presumptions.
No, Your Lordship, the confession which is a very
And the law is
Indeed, Your
that when the case is based on circumstantial evidence, every link should be so securely linked that there is no hypothesis of innocence of the accused. And on every step you are saying presumption.
Your Lordship, with regard to that, even if we leave the particular wine bottles aside, still there are the chain is complete, Your Lordship. From the mother's statement up till the confession, the judicial confession, which is in itself a very heavy piece of evidence.
Anyway, let's hear your partner. Where is your partner?
Much obliged, Your Lordship.
Council seeks admission to approach the dais.
Yes, please.
I, Council number 2, will be dealing with issue number 3 and issue number 4. Issue number 3 before this honorable court is that can a conviction be merely based on the recovery under section 27 of Indus Evidence Act in the absence of any forensic evidence and the recovery of dead body? It is humbly submitted that perfect evidences are seldom to be had.
Yes, a preemptory question. Do you want to suggest that the 27 evidence is the only evidence or this is one of the links available in the chain?
It is one of the links available in the chain. If a conviction can be based on section 27 and it is corroborated with other evidence that is established by my co-counsel, the chain of evidence. That is correct.
The issue is, can conviction be based on the evidence collected under 27 only? The issue is, can evidence collected under 27 alone be basis of conviction? That is the issue. And my question is that whether your case is that this is the only evidence or this is a link in the chain. If you say this is link in the chain, then you have to show us the chain. If you say this is the only evidence, then argument of your partner goes.
Can conviction be merely based on the recovery under section 27 of the Indus Evidence Act in the absence of forensic evidence and the recovery of dead body, as it is already corroborated by the chain of circumstances established. It is humbly submitted before this honorable court that perfect evidences are seldom to be had in this imperfect world. It is humbly submitted before this honorable court that conviction based on the discovery made under section 27 of the Indus Evidence Act is listed, as it is supported by other circumstantial evidences too. The discoveries made under section 27 of Evidence Act is in investigation are very crucial. Such discoveries not only act as the foundation stone of the proceeding with an investigation, but also completes the chain of circumstances. Once recovery is proved by the prosecution, the burden of proof on the defense to refute the same is very strict, which cannot be discharged merely by pointing out the procedural irregularities in making the recoveries. The reliance for the same can be placed on Mukesh vs. State of NCT Delhi. The complete citations for the same are as AIL 2017 Supreme Court 2161. It is humbly submitted before this honorable court that as this section is founded on the principle that if a confession of accused is supported by the discovery of a fact, then it may be presumed to be true and not have been steadfast. As how this fact was only known to the accused and not anyone else. pertinent to note that it comes into operation only if and when certain facts are deposed to as discovered in consequence of information received from an accused person in the police custody, and if the information relates distinctly to the facts discovered. It is humbly submitted that the extent of the information admissible must depend upon the exact nature of the fact discovered, to which information is required to relate. Essentially, under Section 27, disclosure of the statement leading to the discovery of the fact is admissible, and the reliance for the same can be placed on Rumipura Datta versus State of Assam. The complete citations for the same are as AIA 2013, Supreme Court 2422. The discovery of the fact arises by the reason of the fact that the information given by the accused exhibited the knowledge of the mental awareness of the information as to its existence at a particular place. It includes the discovery of an object, the place from which it is produced, and the knowledge of the accused as to its existence. Can the court master please? For the same, reliance can be placed on paragraph number 21 of Asal Muhammad versus State of Uttar Pradesh. Paragraph number 21. The same has been flagged below. Here, the discovery of weapon by the police officer on the basis of information disclosed by the accused makes it more evident that Sumit was brutally murdered by court rape. It is humbly submitted that there are the following essentials of Section 27 of India's Evidence Act, which are upheld by Mohammed Inayatullah versus State of Maharashtra. For the same, paragraph number 12 of the judgment is referred, Your Lordship. Paragraph number 12. It is pertinent to note here that there are the following essentials of Section 27 of the Indian Evidence Act. The fact must have been discovered in the consequence of information received from the accused. The person giving the information must be accused of an offence. The portion only of the information which relates distinctly to the fact discovered can be proved. Before the statement is proved, somebody must depose that article was discovered in the consequence of the information received from the accused. As for the same, I refer paragraph number 5, line number 2 of the moot proposition. It is mentioned that police recovered the weapon of crime on the basis of the information given by both the accused. The last essential ingredient is the fact discovered must be relevant fact. That is to say, it must relate to the commission of the portion of the crime. It is pertinent to note here that weapon of crime was discovered on the basis of the information provided by the accused. The part of the confession by which the accused to the police leading into the identifying the place where the dead body was lying is admissible, and for the same, reliance can be placed on Anuj Kumar Gupta versus State of Bihar. The complete citations for the same are as AIA 2013, Supreme Court 301. The accused have submitted that they have murdered Sumit, dragged his dead body, and biked in the nearby river, which makes it next to impossible for the investigation team to recover the dead body and report any forensic evidence to the options. Next issue. For the juvenile, issue number 4 is document. If your lordship permits, counsel would like to present. Now the counsel will be dealing with issue number 4. The issue number 4 before this honorable court is the conviction of juvenile accused by the trial court justified. It is humbly submitted before this honorable court that every sin has a past and every sinner has a future. It is humbly submitted that Juvenile Justice Act provides the provision and circumstances where a juvenile can be tried as an adult. The relevant provisions of the Act, that is Section 1, Subsection 4, Section 2A, Section 2L, and Section 7 must lead to mean that juvenile children below the age of 18 who are intellectually, emotionally, and mentally mature to understand the implication of their actions and have committed a serious crime do not come under the Act's purview. Such juveniles should be liable to be dealt by the penal law and regular hierarchy of court under criminal justice system administered by India. The reliance for the Dr. Subramanian Swamy and others versus Raju and others. The complete citations for the same as 2014 Supreme Court cases 392.
What is the age of the juvenile in this case?
Relying on the court proposition, there is a grey area regarding the age of the juvenile. It is only mentioned in the clarification that the age is above 12 years.
So we have to take it 12 years on the lower side.
The council is here to assist and request the court that a presiding officer of a session court and investigating agencies who are conducting such kind of investigations on regular basis cannot be so erroneous and ignorant about the law that they have.
No, the law is that before the appellate court, the entire case is open. Do you feel that we cannot pass that order which should have been passed by the trial court?
Pardon, Your Lordship.
Can we pass an order which should have been passed but has not been passed by the trial court? Suppose trial court has made a mistake, right? And the matter comes before us in appeal. Can we set that mistake right?
Not, Your Lordship.
Not. Then what is the purpose of hearing this appeal?
Council is just assisting and requesting the court to presume in the favor of the state that a presiding officer cannot be so erroneous that he surpassed the jurisdiction, that he surpassed the power of juvenile justice court and the jurisdiction of children's court. And an investigating agency that is doing such things on regular basis and conducting such investigations on regular basis.
We want to be clear about our powers. What can we do, what can we not do? If the trial court was oblivious of a particular fact, can we take note of that fact and rectify the mistake committed by the trial court or no?
Indeed, Your Lordship.
But just now you said no.
The council is just requesting and assisting the court to presume in the favor of the state.
Why? Why not to presume in favor of the accused?
As there is
The law is that benefit of every lapse, I underline the words, has to accrue to the accused, not to the prosecution.
indeed, Your Lordship. But here, the council have the judgment of the trial court to support their presumption that the particular investigation has been done, and the fact sheet is silent on the same that the investigation has been done or not has been done. The birth certificate or any other document has been recorded or not.
So you mean to say that even if you don't know what are the powers of the appellate court, the court should know their powers. Thank you.
Council seeks apology, Your Lordship. Council seeks permission to cite the prayer. Wherefore, in the light of issues raised, argument advanced, and authority cited, may this honorable court be pleased to declare that the appeal should be dismissed. The conviction of Ganga and Dev by the trial court should be upheld and pass any other order which may deem fit in the light of justice and good conscience, all of which respectfully submitted, and for this such act of kindness respondent shall be duty bound as it is. Your Lordship, may we start with the rebuttal round?
Yes.
Your Lordship, hearing the contentions of the respondent side, they have constantly come up with two contentions, and somehow neither of them fall within the purview of the four issues that are being raised. They have constantly contended to the court to make a presumption. So here making a presumption equals to making an assumption, Your Lordship, and the law does not work on assumption. It works on evidence. Here the chain of circumstantial evidence is incomplete. Your Lordships have also contended to the same. But the counsel or respondents are constantly emphasized how the chain of circumstantial evidence is complete without providing a shred of evidence. Your Lordship, no forensic evidence was found, no dead body was recovered, and no belonging to Sumit has been found. Conveniently, only the murder weapon has been found. Your Lordship, forensic evidence is of paramount importance in investigations in today's day. The science of forensic investigation in criminal litigation came into force in India in around 1950s, 1957. Started from the state of West Bengal and went to other states.
We are not interested in history of when it came into existence. Put your points.
Indian
The
law.
argument you are now giving should have been given in the affirmative, not in the rebuttal.
Your Lordship, these are the contentions based on the arguments of the respondents. That is why I am giving it in the rebuttal.
You should have argued in the first instance that there is no forensic evidence to connect the.
Yes, proceed. Your Lordship, the respondents have constantly tried to join two isolated incidents. One is the incident with Sumit and one is the incident that took place on Dilbag extension near Canal. Your Lordship, the pool of blood that was found there, the pieces of glass or the bloodstained paper, nothing, everything was connected, but no report of it was given by the police or provided to the appellant. Your Lordship, there is no way to confirm that Sumit has even died in this particular case. He could be missing, and here the appellants will make a presumption that Sumit is missing. Your Lordship, the entire reliance of the respondents, they're relying on circumstantial evidence. They're relying on recovery. But circumstantial evidence and recovery go hand in hand only when they can be corroborated together, Your Lordship. Circumstantial evidence cannot single-handedly be the basis of conviction, especially in this case, Your Lordship.
Okay, thank you.
Thank you.
Do you want to add something?
They have also made many presumptions throughout their arguments. They are saying, Your Lordship, to the fourth issue that the process which is established by the JJ Act has not been followed, but it has never been mentioned in the moot proposition that it has been followed or not. So why we should make this presumption that it has not been followed when it should be presumed in the favor of state? Because in these kind of lawsuits, when we have just one page of proposition, there are so many things left. Even the FIR is not there, charge sheet is not mentioned. So we are presuming things that they have happened. So that is why when these things are not there, we are bound to presume them because it is the format of this particular document.
I fortunately had the opportunity of hearing the arguments of 6 other teams also in addition to the 2 teams there in the finals. And I must confess before you that perhaps we would not have been able to argue in that particular profession as the children have argued. We are really impressed by the extent of research the candidates have put in, their presentation and preparation of memorials. And in certain cases, the confidence level was so much that we were really surprised to see, and we were discussing between ourselves, that at this stage, the stage when they are in the college only, the confidence they are showing, that shows that they are going to rise very high in their careers as advocates or winning or not winning apart. The purpose of moot court is to prompt you to analyze things, to prepare yourself to meet with certain situations, and to put your case in the best possible manner. The only difference between a moot court and a real court is that in the real court, effort is to win the case. But in moot court, it is to demonstrate your ability, your capability, your strength to present your case, to show the extent of research you have undertaken and the drafting skill of the candidate. So as far as these skills are concerned, we are really impressed by all the memorials and presentations made by the candidates. So I wish all the candidates all the best and conclude by saying that the the winners should not take that they are something superior, and the losers, I should not use that word, the candidates who have not been able to make to the mark, should not feel that they have lost the battle. This is only a difference of inches and centimeters. And we are finding very difficult to make a decision that way. Because all the candidates are very good and they have performed well. And the only thing is that the winner should be reminded every time that he has to maintain this level. And those who have not been able to come to the mark, they have to remind themselves that they have to put in a little bit more of effort so that they come to the level from which they have missed today. With these words, I hand over the mic to my brother, Mr. Kuldeep Singh.
Good afternoon, everybody. It was an honor to attend this moot court and hear the arguments of the budding lawyers and judges, and of course successful professionals in any other field. I am very happy that at this stage when they are students, they have developed a good skill of marshalling the facts and then putting forward their reasoned arguments. Sometimes as a lawyer you may not be helped because your case is weak, so your arguments may not satisfy the bench, or sometimes you also may not be able to support those arguments because the inherent weakness in the facts. But in any case, your success lies in marshalling the facts and then presenting your point of view. It may be accepted by the bench or not accepted, that is a different thing. I am very happy that all the voters, they argued very well. They had the confidence at the stage, and then the lawyers. And particularly I very appreciate mooter number 2 from the appellate side, who excelled in her conference at the stage. And I can see her bright career. Of course, the others can also, in the passage of time, they can also reach that stage. So I congratulate the lawyers. Now the judge is ready, and I will request my brother Mahavir Chauhan to announce the judge. Thank you.
Incidentally, we don't have the names of the colleges and the competitors. I request Sharma either to provide us the names or will be pronounced on the basis of the court numbers, and it will be for yes. The winning team is RC2339. And runner of course is 2338. Then we have decided 2 best mooters. First is mooter second is team 2339. And second is mooter 1 in team 2338. Aniha Shaw from Thakur Ramnayan College and Sarvinder Singh from Kurukshetra University. Yes, I stand corrected that the second mooters are also getting prizes as runner-up the race, second best mooters.
Applying the facts to the practical circumstances, because everybody loses interest after the result is out. So this is how the law teaches you to apply the reasoning.
We still have something to keep you glued to your seats. A little bit of more result is to be announced regarding the 6 teams I have heard today in the morning. answers will be given points by the judges, and all the points shall be aggregated, and the top 4 on those grades would make to the semi-finals. They deserve special prizes equivalent to quarterfinals. Still another surprise for the participants.
Now I request all the dignitaries to please come on the stage for giving away the prizes to all the participants as well as the winners. Please.
So it's my proud privilege to present the vote of thanks to this valedictory session. So first and foremost, I express my deep sense of gratitude to the judges of this final competition, Honorable Justice Chauhan ji, Honorable Justice Kuldeep Singh ji, who have kindly accepted our invitation to preside over the proceedings. No talking. Who have kindly accepted our invitation to just preside over the proceedings of the final. So we are further grateful to them, the honorable judges, that they delivered not only the judgments but gave many pieces of advice, not only to the teams but also to the organizers. We are highly obliged, sir, that you have given us so many things, so many guidelines, so many pieces of advice to be more careful, to be more vigilant, and to be more appropriate in the times to come. Thank you very much. So we also had this in the semi-final, the judges both from the academics and the judicial side. So this it was retired district and session judge Mehta ji, retired district and session judge Nangali Saab, and Professor Dr. Kirpal Singh ji, Dr. Manoj Kumar Sharma from Ragnool. So that means the academics and the judicial side, they very kindly spent their valuable time to preside over the proceedings of this semi-finals. We are highly obliged, sir, and we express our gratitude. You have always been a source of inspiration and cooperation to all of us. So we find that this process of extending your cooperation, this guidance and assistance that will continue in future also. So I am also express my gratitude to our Vardi Chairman sir, Vardi Chairman ma'am, Shri Anil Chopra ji, Dr. Anil Chopra, rather I should say appropriately, it's Madam Sugita Chopra ji. And whatever we are doing, it is only with their guidance, with their blessings, with their cooperation. So nothing can happen in an institution if the management is not cooperating, if it is not approving the things. So I have special words to say to ma'am and sir for the reason that whatever we demand for the competition, we say it is only a day before yesterday, and that I went to sir. Then I am to ma'am also. Expressing out that what is to be done, I told that this has been done, that has been done. He said, I said, I am sorry, I am very late, I have come to you for this. He said, it would have been sufficient if you have conveyed me on telephone itself. Why to waste this time? That kind of cooperation, that kind of guidance. So whatever amendments we like to make, whatever the prize money we want to decide, so 51 and there will be 11th of June, it will be covered, at least minimum is covered. Performing their duties, for evaluating the teams, and this most important is what is the core of that, the
जस्टिस कुलदीप सिंह ਰਿਟਾਇਰਡ ਜੱਜ ਪੰਜਾਬ ਐਂਡ ਹਰਿਆਣਾ ਹਾਈ ਕੋਰਟ ਚੰਡੀਗੜ੍ਹ। ਅੱਜ ਇੱਥੇ 12ਵਾਂ ਮੂਟ ਕੋਰਟ ਕੰਪੀਟੀਸ਼ਨ ਹੋਇਆ ਸ਼੍ਰੀ ਆਰ.ਸੀ. ਚੋਪੜਾ ਦੀ ਯਾਦ ਵਿੱਚ। ਇਸ ਦੇ ਵਿੱਚ ਸਾਰੇ ਦੇਸ਼ ਤੋਂ ਵੱਖ-ਵੱਖ ਪ੍ਰਦੇਸ਼ਾਂ ਤੋਂ ਟੀਮਾਂ ਨੇ ਪਾਰਟਿਸਿਪੇਟ ਕੀਤਾ। ਸਾਰੇ ਬੱਚਿਆਂ ਨੇ ਬੜੀ ਮਿਹਨਤ ਕੀਤੀ ਸੀ। ਅੱਜ ਇਸ ਦਾ ਸੈਮੀਫਾਈਨਲ ਤੇ ਫਾਈਨਲ ਹੋਇਆ। ਫਾਈਨਲ ਦੇ ਵਿੱਚ ਬੱਚਿਆਂ ਨੇ ਖੂਬ ਤਿਆਰੀ ਕੀਤੀ ਅਤੇ ਇਸ ਤੋਂ ਇਹ ਲੱਗਦਾ ਹੈ ਕਿ ਬੱਚੇ ਜੋ ਕਿ ਹਲੇ 4th ਈਅਰ ਦੇ ਵਿੱਚ ਹੈ ਜਾਂ ਲਾਸਟ ਈਅਰ ਦੇ ਵਿੱਚ ਹੈ, ਉਹ ਕੱਲ੍ਹ ਨੂੰ ਇੱਕ ਬੜੇ ਅੱਛੇ ਵਕੀਲ ਜਾਂ ਜੁਡੀਸ਼ੀਅਲ ਅਫਸਰ ਬਣਨਗੇ। ਉਹਨਾਂ ਨੇ ਬੜਾ ਅੱਛਾ ਆਰਗੂ ਕੀਤਾ ਫੈਕਟਸ ਦੇ ਉੱਤੇ ਅਤੇ ਲਾਅ ਦੇ ਉੱਤੇ। ਉਹਨਾਂ ਨੇ ਬੜਾ ਵਿਸਥਾਰ ਨਾਲ ਚਾਨਣਾ ਪਾਇਆ ਅਤੇ ਅਸੀਂ ਇਸ ਤੋਂ ਬਹੁਤ ਖੁਸ਼ ਹਾਂ ਕਿ ਬੱਚੇ ਜਿਹੜੇ ਆ ਉਹ ਇੰਨੀ ਤਿਆਰੀ ਦੇ ਨਾਲ, ਇੰਨੀ ਮਿਹਨਤ ਦੇ ਨਾਲ ਆਏ ਸੀ। ਅਤੇ ਇਸ ਦੇ ਵਿੱਚ ਜੋ ਸੀ ਕੋਇੰਬਟੂਰ ਦੀ ਟੀਮ ਸੀ, ਉਹਨੂੰ ਫਸਟ ਪ੍ਰਾਈਜ਼ ਮਿਲਿਆ। ਉਹਨਾਂ ਬੱਚਿਆਂ ਨੇ ਬਹੁਤ ਮਿਹਨਤ ਕੀਤੀ ਸੀ, ਬਾਕੀ ਬੱਚਿਆਂ ਨੇ ਬਹੁਤ ਮਿਹਨਤ ਕੀਤੀ ਸੀ। ਵੀ ਵਿਸ਼ ਕਿ ਇਸੇ ਤਰ੍ਹਾਂ ਹੀ ਹਰ ਸਾਲ ਇਹ ਕੰਪੀਟੀਸ਼ਨ ਹੁੰਦਾ ਰਹੇ ਅਤੇ ਬੱਚੇ ਇਸੇ ਤਰ੍ਹਾਂ ਹੀ ਉਹਨਾਂ ਨੂੰ ਹੌਸਲਾ ਅਫਜ਼ਾਈ ਉਹਨਾਂ ਦੀ ਹੁੰਦੀ ਰਹੇ। ਥੈਂਕ ਯੂ।
I am Justice M.S. Chauhan, retired from Punjab and Haryana High Court. I am very happy to note that I have been able to interact with very brilliant and hard-working students from all over the country. To be very precise, 64 teams from 25 states and union territories from almost all the parts of the country. And having witnessed the participants arguing their cases, I have found that all the students have done a very deep research, have very beautifully drafted their memorials, and have very efficiently and diligently presented their arguments before the courts. Though only one team has to be declared winner, but my experience in this moot court competition has been that every participant who participated in this moot court has been very excellent and very, very brilliant. Another very salient feature of this moot court has been that this is 12th such moot court being organized by St. Soldier Law College, and they started from 8 teams 12 years back and have traveled today to have 64 teams from all over the country. This is a very good effort, not only at educating the students and prompting them to engage themselves in deep research and drafting skills, etc., but also towards national integration, because by way of such competitions, the students from different cultures, different states with different languages have to interact with each other, and they come to know of the different cultures of our great country. Further, the management of this college, particularly the Moot Court Society of the students, they have put in a lot of efforts and have very, very meticulously organized the entire event, which has been successfully concluded today. And the team that participated in the final was really wonderful, and we enjoyed every bit of the arguments put up by the students. Thank you.
आज मूट कोर्ट का दूसरा दिन था और हमारे साथ बहुत से स्टूडेंट खड़े हैं, उनसे भी बातचीत करना चाहेंगे। हेलो जी।
हाय जी।
कैसे हैं आप?
आई एम गुड, आप बताइए।
बढ़िया। आज का एक्सपीरियंस कैसा रहा?
या इट वाज रियली वेल, लाइक the moot court has been conducted in my time for the second time itself, but it was really well, like it was really good. I just more than our expectations.
जी। आपका नाम?
हृदया।
क्या बताना चाहेंगे स्पेशली आज के दिन के लिए, क्योंकि जस्टिस कुलदीप सिंह जी और जस्टिस आनंद जी पहुंचे थे, क्या कहना चाहेंगे?
एक्चुअली ये मेरा पहला मूट कोर्ट है एंड मैं फर्स्ट टाइम पंजाब में आई हूँ। सो ओवरऑल मेरे को मज़ा आया एंड इट वाज एक्चुअली एन ऑनर टू प्रेजेंट आवर केस इन फ्रंट ऑफ जस्टिस। सो
आप कहाँ से आए हो?
हम बॉम्बे से आए हैं दोनों।
ओके।
हाँ।
क्या कहना चाहेंगे आज के दिन के लिए और स्पेशली आज का जो सेकंड मूट कोर्ट था?
एक्चुअली सबसे पहले तो बहुत ऑर्गेनाइज्ड था सब कुछ, तो वो अच्छा था क्योंकि कमेटी वाले एक्चुअली सबसे ज़्यादा तो हमें कमेटी वाले पसंद आए बिकॉज कोई भी प्रॉब्लम थी तो वो लोग हेल्प कर रहे थे एंड दे वर ऑलवेज देयर। सो सबसे पहले तो वो अच्छा था और जजेस भी बहुत अच्छे थे, तो अच्छा इवैल्यूएशन हुआ।
तो आज का एक्सपीरियंस क्या कहना चाहेंगे?
आज का एक्सपीरियंस ओवरऑल अच्छा था, मज़ा आया, डांस भी था तो वो भी अच्छा था, तो इट वाज अ वेरी नाइस एक्सपीरियंस।
थैंक यू सो मच।
थैंक यू।
चलिए किसी और से करते हैं बातचीत। आज मूट कोर्ट कंपटीशन का दूसरा दिन था। यहाँ पर बहुत से दूर दूर शहरों से लोग पहुँचे, बॉम्बे, झारखंड, कलकत्ता, हिमाचल प्रदेश। आज सेंट सोल्जर लॉ कॉलेज में मूट कोर्ट कंपटीशन करवाया गया, दूसरा दिन था आज का, और आज बहुत सारे पार्टिसिपेंट ने पार्टिसिपेट किया और जीत प्राप्त की। कहते हैं जब आप हार्ड वर्क करते हो तो हमेशा आपकी मेहनत आपका साथ देती है। बने रहिए सेंट सोल्जर टाइम्स में। खास स्टोरी देखने के लिए कैमरामैन अनुराग के साथ कोमल।